Judgment in the matter of SC Jamaica against the Secretary of State for the Home Department.
Lord Stevens will deliver the judgment. This is an important case concerning the deportation to Jamaica of the appellant, SC, who is a foreign criminal. It is accepted that there is a real risk that he will be subjected to inhuman or degrading treatment in contravention of Article 3 of the European Convention on Human Rights in urban but not in rural areas of Jamaica. If SC could reasonably be expected to internally relocate in Jamaica from Kingston to a rural area where he would not be exposed to the risk of inhuman or degrading treatment, then deportation would not be in contravention of Article 3 and would not be unlawful on that ground. The central issue on this appeal is whether, in determining the reasonableness of internal relocation, the courts should consider what was due to SC because of his criminality. The question is whether SC's criminal convictions mean that he should suffer more before relocation is found to be unreasonable. SC is a foreign national born in Jamaica in 1991 who came to the United Kingdom aged 10 in December 2001. He has remained in the United Kingdom since 2001. SC's mother, a Jamaican citizen, is a lesbian. It is accepted that lesbians are persecuted in Jamaica on account of their sexual orientation. Whilst living in Jamaica, SC's mother was persecuted because of her sexual orientation. She was beaten, stabbed, and raped by gang members. It is also accepted that those associated with lesbians, including their family members, are persecuted in Jamaica. On account of SC's mother's sexual orientation, a gang shot 2 of her brothers, who survived, and they abused her mother and threatened her sister. SC witnessed assaults on his mother and was also subjected to violence. SC's mother fled Jamaica and came to the United Kingdom. SC joined his mother a short time after. They were together granted indefinite leave to remain in the United Kingdom as refugees. Since coming to the United Kingdom, SC has committed several criminal offences. In 2012, he was convicted of assault occasioning actual bodily harm, for which he was sentenced to 2 years in a young offenders institution. As a result of that conviction, SC is a foreign criminal who qualifies for automatic deportation under the UK Borders Act, unless deportation would expose him to a real risk of inhuman or degrading treatment in contravention of Article 3, or unless it would be in contravention of Article 8, which protects private and family life. The respondent, the Secretary of State for the Home Department, made a deportation order against SC. On SC's appeal, the first-tier tribunal judge, the judge, allowed the appeal, holding that SC's deportation to Jamaica would be unlawful in breach of Article 3 due to a real risk of inhuman or degrading treatment in urban areas of Jamaica, combined with the finding that SC could not reasonably be expected to relocate to a rural area of Jamaica. The judge arrived at the conclusion that internal relocation would be unreasonable for several reasons, including the medical evidence, which was essentially accepted by the Secretary of State, that SC had a highly complex form of post-traumatic stress disorder, had a long history of depression, was deeply traumatized, could be described as institutionalized, and was in need of long-term psychological treatment. In arriving at the conclusion as to the unreasonableness of internal relocation, the judge did not take into account what was due to SC as a result of his criminality. The judge also allowed SC's appeal under Article 8, finding that for most of his life he had been lawfully resident in the United Kingdom, that he was socially and culturally integrated in the United Kingdom, and there would be very significant obstacles to his integration into Jamaica. The Secretary of State appealed unsuccessfully to the upper tribunal. The Secretary of State then appealed to the Court of Appeal, which set aside the decisions of both tribunals and remitted the determination of SC's appeal against the deportation order to the first-tier tribunal for a fresh hearing. The Court of Appeal considered that the judge erred in failing to expressly weigh SC's criminal activity in the balance in relation to internal relocation, and furthermore, that the judge's determination in relation to internal relocation was flawed, as she did not have sufficient material to undertake a holistic assessment. Finally, the Court of Appeal considered that the judge did not analyse whether an Article 8 interference was justified in accordance with the statutory scheme, but rather she treated the Article 8 analysis as a freestanding question outside the statutory scheme. SC now appeals to the Supreme Court, which unanimously allows his appeal for the reasons set out in a judgment given by me, with which the other justices agree, which reasons I will now briefly summarise. The first ground of appeal is whether the judge incorrectly failed to consider SC's criminal conduct as a factor relevant to the reasonableness of internal relocation in Jamaica. This court finds that the correct approach to the question of internal relocation is a holistic assessment involving specific reference to the individual's personal circumstances, including past persecution, psychological and health conditions, family and social situation, and survival capacities. A person's criminal background does not mean that he should suffer more before relocation is determined to be unreasonable. Accordingly, consideration of whether internal relocation is reasonable should not consider what is due to a person as a criminal. Accordingly, the appellant's first ground of appeal is allowed. The second ground of appeal is whether, as the Court of Appeal determined, the judge erred in finding that SC could not reasonably be expected to stay in a rural area of Jamaica. The court finds that the judge did not err, since her finding that SC could not reasonably be expected to stay in a rural area was the logical consequence of her findings, based on the medical evidence that SC needed long-term psychological treatment, in addition to other findings that SC had no family or personal connections anywhere in Jamaica and no familiarity with anywhere outside of Kingston. Accordingly, the appellant's second ground of appeal is allowed, so that SC's deportation to Jamaica in contravention of Article 3 is unlawful, and the deportation order is set aside on that basis. For completeness, this court also considered the other grounds of appeal which relate to Article 8. The third ground of appeal relates to SC's challenge to the deportation under Article 8. The issue is whether, as the Court of Appeal determined, the judge erred in finding that SC is socially and culturally integrated in the United Kingdom, and there would be very significant obstacles to his integration in Jamaica. The court finds that the judge did not err in relation to SC's social and cultural integration in the United Kingdom, as this is a fact-sensitive determination. Furthermore, the judge did not err in relation to the very significant obstacles to SC's integration in Jamaica, having considered in meticulous detail SC's history of mental illness and trauma and need for long-term psychological care. The appellant's third ground of appeal is allowed. The fourth ground of appeal is whether, as the Court of Appeal determined, the judge erred in law in embarking on a freestanding assessment of Article 8, applying the wrong test and failing to give sufficient weight to the public interest in SC's deportation. The court finds no error of law by the judge, who in substance directed herself in accordance with the applicable statutory test. The appellant's fourth ground of appeal is allowed. As I have indicated, the appeal is allowed.
Judgment in the matter of AIC Ltd against Federal Airports Authority of Nigeria.
Lord Sales will hand down this judgment.
This case raises issues about the importance of finality in legal proceedings. If a legal proceeding has reached an apparently final outcome by way of final judgment and final order, To what extent, if at all, is the judge permitted to revisit and change that outcome because she has had second thoughts or because the circumstances of the case have changed? The basic rule is that, subject to certain exceptions, once a final order in civil commercial proceedings has been made and sealed, the judge no longer has a discretion to change it. But before the order is sealed, there is the possibility of changing it. What principles apply if the judge is invited to change her order in the gap between declaring in open court what the order is and the administrative step being taken to seal that order? The Supreme Court rules unanimously that the width of the discretion for the judge is narrow because the judge has to give great weight to the principle of finality in litigation. All questions of discretion in relation to civil procedure are governed by the overriding objectives set out in the civil procedure rules. That says that cases are to be decided justly and at proportionate cost. The Supreme Court rules that the principle of finality in litigation is inherent in the overriding objective and has to be brought fully into account when a judge exercises her discretion whether to change a final order before it is sealed. In this case, as the Court of Appeal identified, the judge did not give proper weight to the principle of finality. She treated her discretion to change her mind and her order as being too open-ended. On the other hand, the Supreme Court considers that the Court of Appeal adopted an overly rigid approach to the way in which the principle of finality should be brought into account. The result is that neither of the two lower courts have approached the exercise of discretion in the correct way, so the Supreme Court has to exercise the discretion again in light of all the current circumstances of the case. The particular facts of the case are that the respondent, AIC, and the appellant, the Federal Airport Authority of Nigeria, which I will call FAN, are locked in a dispute regarding the construction of an airport in Nigeria. That dispute went to arbitration and AIC won. By the arbitration award, FAN was ordered to pay $48 million to AIC plus interest. However, FAN is in the process of challenging the lawfulness of that award in the Nigerian courts, which have supervisory powers regarding the arbitration. At this stage, it is unclear whether the award will be set aside or upheld in the Nigerian proceedings. Where a party holds an arbitration award, they can take it to the courts of another country, such as the United Kingdom, and ask the courts of that country to give permission for the award to be enforced against the assets of the losing party, in the same way as if it were a judgment issued by the courts of that country. That is what happened in this case. AIC sought permission from the High Court to enforce the arbitration award in England. At FAN's request, the High Court adjourned the claim pending the outcome in the Nigerian proceedings. This adjournment was on the condition, however, that FAN provide security now of $24 million by way of a bank guarantee so that AIC could be sure to get at least that amount with a minimum of effort if it won in the Nigerian proceedings. FAN was given a time limit within which to provide the guarantee. Despite being granted extensions of that time limit, FAN still failed to provide the guarantee in time. FAN left matters to the last minute to ask the government of Nigeria for necessary consents to set up the bank guarantee and then ran out of time. As the guarantee was not forthcoming in time, AIC went back to court to ask for a final order for permission to enforce the arbitration award, regardless of what might happen in the Nigerian proceedings as they dragged on. Since FAN had simply failed to comply with the requirement to provide the bank guarantee in time, it seemed an open and shut case. The judge gave a short oral judgment and made an order permitting AIC to enforce the award. However, the order was not sealed immediately. Later, that same day, FAN finally obtained the required bank guarantee. It provided the guarantee to AIC and applied to the judge to reopen and set aside the order she had made. FAN wanted the enforcement of the arbitration award to be adjourned until the end of the Nigerian proceedings and said that now, at last, it had provided the bank guarantee for $24 million, which the court had previously said was to be the quid pro quo for that. Even though she had given a final judgment in open court and had made an order in favour of AIC, the judge decided to exercise her discretion in favour of FAN to change that order. She did not think that significant blame attached to Fan for the delay in obtaining the bank guarantee. It would be unfair to allow AIC to have both permission to enforce the arbitration award against any Nigerian assets it could find in England, and to have the benefit of the $24 million bank guarantee, which provided AIC with a major benefit in enforcing the award, which was only ever intended to be an alternative to permission to enforce, not an additional benefit. So the judge withdrew permission for AIC to enforce the arbitration award in England. AIC promptly appealed. It said the judge had made a final order, Fan had only itself to blame for the delay, and the late provision of the bank guarantee was not a relevant change of circumstances. The Court of Appeal held that the judge had not given proper weight to the principle of finality. She should have adopted a two-stage approach, asking first whether the application to amend the order should be entertained at all, and only if that was answered yes, going on to consider how her discretion should be exercised. Also, the judge had erred in her assessment of Fan's responsibility for the delay in providing the guarantee. Fan had been at fault for delaying without excuse in seeking the consents it needed to get in place from the Nigerian government. Also, in the view of the Court of Appeal, the judge had erred in thinking that the late provision of the guarantee was a relevant change of circumstances. For all these reasons, the Court of Appeal allowed AIC's appeal. The judge had erred in her approach, and it fell to the Court of Appeal to re-exercise the discretion. It did so by reinstating the judge's original order giving permission to enforce the arbitration award. As a result, AIC had both an unlimited right to enforce the award and the benefit of the guarantee as an asset against which to enforce. AIC accordingly called on the guarantee, which was paid in full by Fan's bank. So AIC has already received $24 million towards satisfaction of the arbitration award. Fan appealed to the Supreme Court. Further enforcement of the award was stayed pending the outcome of the appeal. This court allows Fan's appeal, but only in part. It agrees with the Court of Appeal that the judge went wrong in exercising her discretion by not giving sufficient weight to the principle of finality and by omitting to find that Fan bore significant responsibility for the delay in arranging to provide the guarantee. On the other hand, the Court of Appeal's own approach to reconsideration of an order already made was somewhat too rigid, and it was wrong to say that the provision of the bank guarantee was not a significant change of circumstances. It was. In fact, it was a highly relevant change of circumstances, since it meant that AIC had both an order permitting enforcement of the arbitration award and a bank guarantee on which it could, and did, call immediately to be paid a large part of the money covered by the award. The guarantee was only ever supposed to be provided by Fan as an alternative to immediate enforcement of the award, not to give AIC an asset which it could immediately enforce against without any effort. The Supreme Court has therefore had to decide for itself how the relevant discretion to revisit the original enforcement order made by the judge should be exercised. After giving substantial weight to the principle of finality, this court has decided, on balance, that the provision of the bank guarantee the same day as the enforcement order was made, and the fact that AIC has obtained payment under the guarantee are significant changes in circumstances which, in accordance with the overriding objective, justify allowing the appeal to a limited degree. The enforcement order is set aside, and the adjournment of AIC's application to enforce is restored. However, at this stage, AIC is entitled to keep the $24 million it has received under the bank guarantee and will not be ordered to repay it. AIC is therefore materially better off than it would have been had Fan provided the guarantee in proper time. In the court's view, this gives due recognition to the principle of finality and penalises Fan to an appropriate degree for its failure to comply with the timetable for provision of the guarantee as set by the judge.
Judgment in the matters of HW Children and in the matter of HW Children number 2.
Team Siobhan Keegan will hand down this judgment.
These appeals arise in a family law context. They concern care orders made in relation to 3 children who are now aged 14, 11 and 9 respectively, and referred to as C, D and E in this judgment. The appellants are the children's mother and her partner. In addition, the mother has some other children. The eldest two are independent and now aged 22 and 19 and live outside the family unit. The 22-year-old, who is referred to as A, features prominently in this case, as will become apparent. The mother also has a young child, now aged 2, referred to as F, with her current partner, with whom she lives in the family home. Whilst this youngest child is not the subject of this appeal, the decisions made in relation to the other 3 children will inevitably have a bearing upon where she should live in the future. The local authority began its involvement with the family when the mother herself was a child. She suffered from sexual abuse at the hands of one of the children's fathers, referred to as F2, resulting in a background of sexual risk within the family dynamics. There has also been local authority involvement with the family over many years due to issues of neglect. Court proceedings for the removal of C, D and E from the family home were first attempted in March 2012. This was precipitated by F2 being found in the family home. At that time, the children were not removed, although A, who was then a child, was made the subject of a care order. An injunction was also made against F2 to prevent him from visiting the family home. In October 2019, the family's case was closed by social services on the basis that they had made considerable progress and the children were happy. The current proceedings were triggered by the conduct of A. He is a troubled young man. Flowing from this, the mother was expected by social services to prevent him from staying in the family home and being unsupervised around the other children. Nevertheless, this young man visited the house for short periods. When he was at the home on the 18th of November 2019, he sexually abused the youngest child, E, whilst the mother and her partner were distracted. This was not reported to social services until the 21st of November 2019. In March 2020, court proceedings were issued by the local authority seeking care orders and removal from the home, not only of C, D and E, but also of F. The local authority's case against the mother and her current partner was that they had failed to protect E and the other children from A, and failed to notify the social services when he abused E in the home. The local authority's initial application for an emergency protection order to remove C, D and E was refused. However, a non-molestation order was made against A, which, among other things, prevented him from coming to the family home. The proceedings came to court for hearing before the judge. The judge made certain factual findings in relation to A's assault on E in November 2019 at the threshold criteria stage of proceedings. Thereafter, a welfare hearing took place. On the 26th of July 2021, the judge decided that care orders should be made for C, D and E, which meant that they would be removed from the family home into separate long-term foster placements. The judge also decided that the case of F should be adjourned. The Court of Appeal upheld the judge's decision by a majority. The mother and her partner appealed. Their grounds of appeal were refined by the Supreme Court into 2 questions concerning the making of the care orders for C, D and E as follows. First, in order to decide whether the care orders were proportionate, was it necessary for the judge, as a matter of law, to assess the likelihood that if left in the mother's care, A, the children would suffer sexual harm, B, the consequences of such harm arising, C, the possibility of reducing or mitigating the risk of such harm, and D, the comparative welfare advantages and disadvantages of the options presented. The second question was whether the judge erred in law by failing to make any proper assessment of those matters. The Court's ability to make a care order is an intrusive power which engages Article 8 of the European Convention on Human Rights, the right to private and family life. Accordingly, the court may only make a care order if it is necessary and proportionate to do so. When deciding whether a care order is necessary and proportionate, the judge must evaluate all of the available options for the child or children concerned. Where there is an appeal from a care order, the function of an appellate court is to review the judge's findings and to intervene only if they are wrong or if the process of the judge's reasoning was inadequate. An appellate court will not conduct a fresh evaluation of whether a care order is necessary and proportionate for itself. The core argument made by the appellants was that the decision of the judge to make the orders in relation to C, D and E was wrong because the judge failed to consider other less interventionist options which would mitigate the risk of sexual harm. This argument was prefaced by the fact that no instances of harm had occurred since November 2019, when a protective framework of non-molestation and supervision orders was put in place. The suggested protective measures included the ongoing use of a non-molestation order against A and an injunction against F2, alongside a variety of orders available under the Children Act. The local authority accepted that the judge had not specifically considered the range of powers available to the court as required under the welfare checklist. However, the local authority contended that the judge's decision, read as a whole, confirmed that the judge had considered all possible options. The present case does not involve any challenge to the judge's findings of primary fact, nor is there any challenge to the judge's conclusion that the legal threshold for the making of a care order has been crossed. Instead, the appeals concern whether the judge erred in the third stage of his analysis, namely in finding that the care orders were necessary and proportionate. The first issue before the court was whether it was necessary for the judge, as a matter of law, to assess the four matters I have referred to. This court has no hesitation in concluding that the judge was required to assess all four of those matters. Their pertinence is an inevitable consequence of a holistic evaluation in a case of this nature, and specifically flow from consideration of the welfare checklist. The second issue before the court concerns whether the judge erred in law by failing to make any proper assessment of these four matters. In this regard, there is no valid argument in relation to the assessment of whether the children would suffer sexual harm and the consequences of such harm arising. This appeal boils down to considerations C and D, which concern mitigations and options, and has focused on the judge's reasoning in relation to those requirements as follows. The judge's treatment of the facts and evidence was thorough. However, the judge did not mention the efficacy of the injunction against F2 and the non-molestation order made against A. Moreover, his decision was insufficiently founded on the necessary analysis. Indeed, one looks in vain for the critical side-by-side analysis of the available options and for the evaluative, holistic assessment which the law requires of a judge in proceedings such as these. The process adopted by the judge was therefore flawed, as it did not adequately assess the prospects of various options to mitigate the risk of sexual harm. The decision was insufficiently founded on the necessary analysis and comparative weighing of the options for each child. In the absence of this evaluative analysis, which is required, this appellate court cannot determine whether the orders made were proportionate and necessary. An adjudicating court will need to scrutinise revised plans for the children and be satisfied as to any mitigations which might address the identified risks. This court is not equipped to conduct that exercise. It would be inappropriate for the Supreme Court, as an appellate court, to conduct a fresh proportionality assessment. Instead, the only realistic course is to remit the case for rehearing. We therefore agree with the analysis of the minority in the Court of Appeal. The Supreme Court unanimously allows the appeal and remits the cases for rehearing before a different judge who will make a fresh assessment on the ultimate outcome for the children who are affected by this case.
The court will now adjourn.